amount of approximately $2.8 billion is currently allocated. The statute authorizing this category, 26 U.S. Code 142M, defines qualified highway or surface freight transfer facility to mean, among other things, any surface transportation project which receives federal assistance under Title 23. The Department has consistently understood this language to mean any surface transportation project which receives assistance from Title 23, not limited to highways, is eligible for private activity bond issuance. All Aboard Florida originally applied for an allocation of $1.75 billion in PAB authority for both Phase 1 and Phase 2 of their project, later named Brightline, in August of 2014. Brightline Phase 1 is a passenger rail service from Miami to West Palm Beach, and Phase 2 would extend the service to Orlando International Airport. The application indicated that in the time since the planning process for the All Aboard Florida project had begun, the Florida Department of Transportation has spent Title 23 funds improving railway highway grade crossings along the project corridor. Based on these expenditures, the department determined that the All Aboard Florida project was a surface transportation project which receives federal assistance under Title 23. And it therefore qualified for a private activity bond allocation under 26 U.S. Code 142 M1A. The department issued an allocation letter in December of 2014. The department acted subsequently to extend that allocation twice. In September of 2016, All Aboard Florida submitted a new application requesting a $600 million allocation for Phase 1 of the Brightline project. It simultaneously requested that the existing $1.75 billion allocation be withdrawn. In November of 2016, the old allocation was withdrawn and the new allocation was granted. $600 million in private activity bonds were subsequently issued for Phase 1 in December of 2017. These bonds helped fund construction of new stations and track infrastructure. On December 5th of 2017, All Aboard Florida applied for an allocation of $1.15 billion in private activity bond authority for Phase 2 of their project. This allocation was granted in December of 2017 and has an expiration date of May 31st, 2018. Thank you again for the opportunity to testify today regarding the department's private activity bond allocation process to the All Aboard Florida Brightline project, and I look forward to your questions.
19 seconds. Pretty good for government work, Mr. Perthy.
Thank you for your testimony. Is it Goddard? Is that correct? I don't want to pronounce it wrong the whole time. So 5 minutes, Mr. Goddard. Thank you. You're recognized.
Thank you, Chairman. Chairman Meadows, Ranking Member Connolly, and members of the subcommittee, thank you for the invitation to participate in this hearing. My name is Patrick Goddard, and I am the President and Chief Operating Officer of Brightline. As many of you know, Brightline has revived the legacy of Henry Flagler, who introduced passenger rail to Florida over 100 years ago. We launched our service in January between Fort Lauderdale and West Palm Beach, and Miami is set to begin operations in the coming weeks. Early works to Orlando are also now underway, which will connect major economic engines for the third largest state in the country. In doing so, we have created employment for over 10,000 people. I'm excited to report that early ridership numbers are higher than anticipated, and support for our current service and future expansion opportunities from consumers, elected officials, and the business community has been nothing short of overwhelming. This model serves city pairs that are too short to fly and too long to drive. It's working, and it will work in other markets across the country. There was never a more important time than now to build this system that will benefit all of Florida and its visitors. Today, 400 million trips are taken annually in this market, relying on roads and airways that are among the most congested in the nation. Driving speeds on the Interstate 95 highway in South Florida currently average 34 miles per hour with no capacity for improvement. With 20 million residents and 116 million visitors, enhanced mobility between these markets is vital to meeting the growth trajectories in this region. Brightline will eventually take up to 6 million trips off our highways, giving residents and tourists a safer, more reliable, and convenient means to travel around the state. That said, I would like to address the topics that have been brought to bear today. First of all, Brightline is a private company and is privately funded. Contrary to propaganda disseminated by some of our opponents, private activity bonds are not government funded and taxpayers are not at any risk whatsoever. The federal government does not guarantee the bonds, subsidize the interest rate on the bonds, or assume any liability for the project's losses or cost overruns. Private investors assume 100% of the risk, and local governments receive millions of dollars in new tax revenue. In fact, it is estimated that Brightline will generate more than $650 million in tax revenue to federal, state, and local governments, and there will be $6 billion in positive economic impact over 8 years. In addition to the PABs, which are collateralized by our assets, we have invested over $1 billion in equity, which is at risk, not an insignificant amount of our own money. Despite this investment, at our own risk, and for public benefit, might I add, we still face opposition from a minority of narrow-minded residents of 2 counties along our corridor who are willing to support passenger rail everywhere, it seems, except in their own backyard. The fact is, I concur with Mr. Connolly. President Trump's infrastructure bill is what is actually on trial in this room. And as long as we allow a small group of obstructionists to tie up courts and spend taxpayer dollars on frivolous lawsuits to stand in the way of necessary progress. On safety. Safety has been Brightline's priority since the inception of this project back in 2012. APTA has published a recent study demonstrating that train travel is 90% safer than travel by car. With 700 deaths year to date on our state's roads, I would say that percentage is far higher in Florida. Rail opponents to our north claim that recent incidents validate their claim that passenger rail is unsafe. But they choose to ignore the facts and the actual police reports surrounding these incidents, a common theme of bending information to suit their anti-progress narrative. In every incident to date, all of the safety and warning systems worked exactly as intended. These were all examples of individuals circumventing the very equipment that was put in place to protect them. It's impossible to have a conversation about rail safety without discussing opioids and mental health. Every person who has died on our railroad has either chosen to end their lives or been under the influence of drugs. In every aspect of this project, Brightline has gone above and beyond what is required by regulators and what is expected of others in our industry. Early ridership and guest feedback tell us we are bringing a much-needed solution to South Florida. Not only are people in the state excited about Brightline, but in January, your colleagues Bill Schuster and Peter DeFazio took part in our launch, tried our trains, and walked away overwhelmingly impressed. I welcome you and all members of this subcommittee to join us in Florida and to see our impressive operation. I thank you.
Mr. Crandall, I'm going to recognize you, and I'll give perhaps one just caveat based on Mr. Goddard's opening remarks. Try to keep personalities out of it. And Mr. Goddard, I don't think it serves your case well when you call some of Mr. Posey and Mr. Mass's constituents narrow-minded and obstructionists. But that's mine. I would just, the rest of the panel, I would just encourage you to try to keep personalities out of it. Mr. Crandall, you're recognized for 5 minutes.
Noted.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, Ranking Member Connolly, members of the subcommittee. Thank you for inviting me. My name is Robert Crandall. I live in the Treasure Coast region, and at one time I was chairman of American Airlines. CARE Florida, where I've served on the steering committee since 2014, is a coalition of Treasure Coast citizens and organizations trying to preserve the character of the several communities through which All Aboard Florida proposes to run 32 daily passenger trains at 110 miles per hour. I'm here to answer a straightforward question. Should this project be subsidized by federal taxpayers? CARE Florida believes the answer to that question is no, for 3 reasons. First, the DOT's allocation of $1.15 billion in private activity bonds, or PABs, to All Aboard Florida is improper, unlawful, and in direct contravention of congressional intent. Second, because All Aboard Florida is unsafe as designed. And finally, because in Care Florida's judgment and mine, the project cannot be financially successful. I'd like to spend the next couple of minutes addressing the PABs and then add a word on financial viability. All Aboard Florida portrays itself as a private enterprise, but it has demonstrated an insatiable desire for taxpayer-subsidized financing and is unlikely to be able to finance its project without it. In August of 2016, a U.S. District Court ruling on a DOT allocation of $1.75 billion, the original allocation, cited legitimate questions about All Aboard Florida's commitment to completing the project without PABs. First of all, and I quote the court, PAB-based financing is not just the current financing plan, it appears to be the only financing plan. And I ask that that ruling be made a part of this hearing record. Unhappily, I beg your pardon?
Say without objection, so moved.
Unhappily, the U.S. DOT, in our judgment, does not have the statutory authority to allocate PABs for this type of passenger rail project. The Internal Revenue Code allows the issuance of tax-exempt PABs only if the project to be financed falls into one of the 15 specified categories on the chart. A high-speed intercity rail facility would qualify, but no one, not AAF and not DOT, disputes the fact that AAF is not high-speed and does not qualify. DOT has chosen, therefore, to approve PAB allocations based on the theory that it is a qualified highway or surface freight transfer facility. But AAF is a passenger railroad. It is not a highway. It is not a freight transfer facility. Nonetheless, DOT has allocated $1.15 billion, the largest PAB allocation to date, claiming that AAF can be considered a highway because once, years ago, the Florida Department of Transportation spent $9 million in Title 23 highway funds to improve highway rail crossings in the separately owned Florida East Coast Railway corridor in which AAF will run. In recent years, there have been several occasions, on which the Obama administration or individual members of Congress have proposed to amend the statute to include passenger rail projects that do not meet the current high-speed definition. None of those proposals were ever enacted, but the fact that they were proposed is a clear admission that the authority does not exist. In closing, I'd like to comment briefly on AAF's projected financing. In order to succeed, they must obviously raise enough revenue to cover their costs. Twice, in 2013 and in 2017, they have commissioned revenue studies. In 2017, they proposed a study which increased the 2013 assumptions by doubling fares and thereby increasing, according to the study, passengers by 52% and tripling revenue. Now, if anybody, when I was running American Airlines, had told me that we could change a route from a loss to a success by doubling our fares and would thereby triple our revenues, I would have paid little attention. We are glad this hearing is taking place. We are glad you are watching. We hope you will decide to end this debacle. Thank you very much.
Thank you, Mr. Crandall. Chief, you're now recognized for 5 minutes.
Thank you very much. Chairman Meadows, Ranking Member Conley, and members of the subcommittee, thank you very much for inviting me to testify here today on the All Aboard Florida Passenger Rail Project. My name is Daniel Waters. I'm a Division Chief for the Fire Rescue Department in Martin County, Florida. Martin County is located in the Treasure Coast region and has 151,000 residents and 538 square miles. As a Division Chief, I'm responsible for emergency preparedness, response, and field operations in the county. Within the Florida East Coast Railway, in which the All Aboard Florida high-speed passenger train project is proposed, Martin County has 27 at-grade crossings. Currently, 10 to 14 freight trains pass through our region at speeds typically between 30 to 40 miles per hour. On the upgraded rails, All Aboard Florida and FECR plan to run 32 high-speed passenger trains up to 110 miles per hour and freight trains up to 70 miles per hour through our community. The significant increase in the numbers and speeds of those trains passing through our traffic-congested at-grade crossings will negatively impact public safety. The project will quadruple our railroad crossing closures, resulting in additional delays for fire rescue. The survivability of patients decrease each minute these services are delayed. The potential for injuries and fatalities is real, not hypothetical. According to the FRA Accident Incident Overview from 2011 through 2017 in the FECR quarter, 107 fatalities and 191 injuries occurred, with 16 fatalities and 33 injuries in 2017 alone. If 32 high-speed passenger trains, as well as additional faster freight trains, are added, statistically, these fatalities and injuries will increase based on the current trends. In fact, this is already occurring. Since the start of the AAFF trial runs between West Palm Beach and Fort Lauderdale, the all-aboard Florida trains have struck and killed 5 people and injuring others in separate incidents involving pedestrians, bicyclists, and motorists. When busy traffic occurs on roadways, motorists can inadvertently get caught at traffic signals, resulting in them stopping on the rails. 2 such incidents occurred on February 14th and March 10th of 2018. In one incident, a vehicle followed another onto the tracks, which had inadvertently stopped, leaving it stranded. In the second case, an elderly driver stopped for a red light when the crossing guards came down. The 2 incidents I referred occurred in a span of less than a month on just a 46-mile short span. In 2017, our response vehicles crossed the railroad tracks approximately 17,000 times, responding to incidents as well as transporting patients to area hospitals. Based on the estimated increase in the rail traffic, there will be substantially more delays if the All-Aboard Florida project proceeds as planned due to a lack of grade separation through our community. In our downtown area, a nearly 100-year-old single-track bridge still exists. A parked freight train waiting to pass another train could substantially cause delays to our downtown community and, in fact, impact for public safety and response to hospitals. Within the increased potential of collisions comes the potential for devastating chemical releases. To make this point, I would like to refer to a chart I have on the easel. In 2015, Martin County conducted a vulnerability analysis to examine the potential for an impact of a single rail car crash resulting in a chemical release. This slide shows a potential for a catastrophe based on the rail corridor proximity to the community. If you'll notice in the shaded areas, the red areas are where patients would have life-threatening injuries. In the orange areas, serious irreversible conditions, and the yellow area where they would have effects as well. I summarize by simply stating that this shows a potential for significant harm to occur due to the track's proximity to that of Martin County. There are additional harmful impacts, such as no pedestrian crossings at 10 of the 27 at-grade crossings in Martin County. All Aboard Florida has told the county that local taxpayers will be responsible for 100% of those costs to add those safety features. As well, with the increase in the additional track, there will be insufficient spacing at some locations for buses to stop between the traffic light and the rail. Because of this, it's essential that the installation of vehicle presence detection as well as dynamic exit gates are installed at all of the crossings. Martin County is gravely concerned about the public safety risks and the increase in the proposed All Aboard Florida project. Mr. Chairman, the FRA approved a $1.15 billion bond allocation for this project based on the FIAS and the ROD that contained critically deficient safety analysis and recommendations. Given the track record for injuries and fatalities within the rail corridor, the FRA's decision to approve the project without the safety measures is sought to be startling and dangerous. Thank you very much.
Thank you, Chief. Is it Reingold? All right, Mr. Reingold, you're recognized for 5 minutes.
Thank you. Thank you, Chairman Meadows. Thank you, Ranking Member Connolly.
And you may want to pull that a little bit closer. We're getting older. Our hearing is not quite as good as it used to be.
Thank you for allowing me to testify today. My name is Dylan Reingold. I'm the county attorney for Indian River County. Indian River County is a small county located on the east coast of Florida. It is south of Kennedy Space Center and north of West Palm Beach. We have approximately 146,000 people who live in Indian River County, mostly in the population centers of the city of Vero Beach and Sebastian. As you may know, Allboard Florida's proposed Brightline service will travel from Orlando to Miami with stops in Fort Lauderdale and West Palm Beach. It will then zip through Indian River County and our 31 at-grade highway railroad crossings and near businesses and schools and residences at over 100 miles an hour. Please understand that safety is our biggest concern. However, that issue will be addressed by other speakers today. I will therefore focus upon the financial impact that Allboard Florida will have upon local governments like Indian River County. The Higher Speed Passenger Rail project is subject to the National Environmental Policy Act. In NEPA documents, the Department of Transportation has stated that it expects Indian River County to pay for the maintenance of safety improvements at-grade crossings for eternity. Let me repeat that because that is very important to my community. The United States Department of Transportation and the private company funded by a Japanese hedge fund expect Indian River County and other local governments to pay for the maintenance of those safety improvements at the crossings in eternity. We know where this theory originated. Indian River County currently has license agreements with the Florida East Coast Railway for the crossings within the jurisdiction. The truth is FECR has these agreements with local governments up and down the east coast of Florida. That is because the railroad, which was built approximately about 1925, existed long before the highways and roads that were necessary to support a population that has since grown by 10,000%. So Indian River County, like our sister communities to the north and south of us, have funded this arrangement with FECR for many years, which may not necessarily be fair, represents the status quo. Now Allboard Florida is demanding to piggyback off these arrangements and to change the terms of the deal. This cannot be permitted. This is an unfunded mandate upon the local governments. First, Allboard Florida is not an affiliate company. It is not a sister company of FECR. It is a separate company. Second, the speed of Allboard Florida well, at least was not contemplated when these agreements were executed by the parties. The existing railway corridor in Florida, in Flagler's East Coast Railway time period, has never had a higher speed passenger rail system. The original service was slow. It had many stops. It ceased to exist in 1968. And the evidence of this is that you have 159 at-grade crossings in populated areas between West Palm and Cocoa. To allow for the increase in speed is unconscionable. These trains will travel at more than 3 times the average speed of the current freight trains today. And the steep increase in these speeds mandate the need for improvements at the highway grade crossings. While Allboard Florida has recently offered to pay for these installation of these improvements, it still expects and demands that local governments like Indian River County pay for the maintenance of these facilities forever. An initial cost estimate performed by Indian River County estimated that this will cost Indian River County approximately $8.2 million through 2030, which is a significant sum of money for a small county like ours. In closing, I want to say that Indian River County prides itself on being a fiscally conservative county. We keep our taxes low, we limit the size of our government. But we won't be able to limit the costs that we spend on the maintenance of these facilities. That is because local governments like ours have absolutely no control over the costs of the maintenance for these facilities. So, in closing, I specifically want you to remember 2 things. 1, we are concerned about safety, and 2, we do not want the bills for these safety and maintenance costs to come from the pockets of our constituents. That is unacceptable. Thank you very much.
Thank you, Mr. Reingold, for your testimony. As a personal note, I want to, probably way before your time, some 40 years ago when there was a younger, thinner, more agile individual, I used to take Highway 60 across from Brandon, Florida to surf at Sebastian Inlet. And so that was my indoctrination to Indian County. I'll now recognize the gentleman from Florida that has been a strong advocate along with the gentleman to his left, Mr. Posey, on this particular issue, the reason why we're having this hearing, Mr. Mass, for a series of questions.
Chairman, I'm going to have to think about you with Surfer here for a while now. Thank you all for being here. Mr. Goddard, I thank you for taking the time to be here for this hearing. Just with a couple of for-the-record questions, do the all-aboard Florida trains currently operate in speeds of excess of 150 miles per hour?
No, they do not.
Thank you, sir. Mr. Berthe, did the Department of Transportation approve $1.15 billion in private activity bonds to All Aboard Florida as a qualified highway or surface freight transfer facility?
Yes.
Thank you. I like to think that if Congress wanted to fund trains through the private activity bond process outside of those that are high speed, those in excess of 150 miles per hour, they would have put that into the list of 15 eligible projects for private activity bonds. Mr. Berthe, Section 142, Title 26, it does define eligibility for private activity bonds. A qualified highway or surface transfer facility is any surface transportation project which has received federal assistance under Title 23. So I want to ask, did any Title 23 money go to the All Aboard Florida project?
Thank you for the question, Congressman. In the application from All Aboard Florida that the Department of Transportation received, All Aboard Florida indicated that over 2012, 2013, and 2014, Title 23 funds were used on the corridor. That was after the announcement from All Aboard Florida.
The corridor or the All Aboard Florida project?
I'm sorry?
The corridor being FEC corridor or the All Aboard Florida project specifically?
The corridor on which the All Aboard Florida trains will run.
So if All Aboard Florida did not specifically receive funds, I would wish that the department would withdraw their award letter for private activity bonds. But I would ask, was there actually monies distributed or deposited to All Aboard Florida specifically? That project, were there monies distributed into an account for a surface transportation project to All Aboard Florida?
The Florida Department of Transportation manages Title 23 funds in the state of Florida.
So are you saying, not to your, to the best of your knowledge, were dollars specifically put into an All Aboard Florida account, they went to FDOT, Florida Department of Transportation?
We are not aware of any funds going to a All Aboard Florida account. However, the application which the Department of Transportation reviewed did indicate that funds were used by the Florida Department of Transportation from Title 23 on the corridor on which the All Aboard Florida trains run, enabling it to be eligible for assistance under private activity bond statute.
Thank you for that. And I think this is an important point of what we're getting at here, and it has a very broad implication for what goes on with private activity bonds across the breadth of this country. This is the problem. Congress has given a list of projects to provide private activity bonds to. As it relates to rail, Congress said very specifically high-speed rail over 150 miles per hour. You said, for the record, that's not you. We're not disputing that. Nobody is. So what we're using here is this kind of doublespeak that I think often ticks people off, where everybody is labeling this train something that it's not. We're saying because it once in one section of a corridor, not even the same project, had some infrastructure upgrades done to the project, that by that rationale, an intersection was fixed somewhere on the rail, that an entirely new project is subject to being eligible for private activity bonds. And I think that's what we're getting at here. I would like to get to something else very quickly here. Mr. Goddard, All Aboard Florida's CEO Mike Renninger testified in June of 17 on T&I committee that I sit on. He testified to me that All Aboard Florida is not publicly funded at all. It's completely an investment of private sector capital. However, Brightline's private activity bond application from December of 17 reads, the project has received financial assistance under Title 23, that's a federal assistance, and eligibility for private activity bonds under Title 26 mandates that the financial assistance is in fact federal assistance. So my question would be, when the CEO, Mike Renninger, testified before T&I in that time, was he lying to me when he said that that the Brightline project hadn't received any federal funding, or was there a lie to the Department of Transportation on the application in saying that private activity bonds are eligible because they have received private assistance? That to me sounds like two completely different answers.
Yeah, no, he did not lie. He did not lie to you. That funding was relative to safety improvements.
And with that, my time has expired, and I will yield back. Thank you.
The chair recognizes the gentleman from Virginia for a series of questions.
I thank the chair and thank the panel for being here. Mr. Berthe, we heard the testimony. Mr. Crandall says, inter alia, that this is a misuse of PABs, and it's pretty clear in the code. This is a circumvention of that. Chief Wouters talks about safety, that there are inherent safety problems giving at-grade crossings, multiple at-grade crossings that put the risk at public, and were never intended for a train of this kind of capacity speed-wise, putting the communities at risk. Mr. Reingold makes an argument, as somebody who comes from local government I can sympathize with, that in effect, whether by design or not, approving this project puts a permanent unfunded mandate on local governments to maintain whatever safety measures are put into place or not put into place from now until the end of time. Any of these concerns factor into the decisions at the Department of Transportation about this project?
Thank you, Congressman. So to be clear, the Department of Transportation's responsibility in providing an allocation for private activity bonds is to determine statutory eligibility. And the department has historically interpreted any surface transportation project that utilizes Title 23 funds to be eligible for the phrase qualified highway or surface.
Mr. Berthe, are you is it your testimony that upon that examination, irrespective of these concerns, the department determined it was qualified?
The department determined that the application met the statutory eligibility to being able to use private activity bonds.
So, not to create the argument, because I don't wish to have the litigation by surrogate here, but so you take direct issue with Mr. Crandall's testimony that it most certainly does not. Those are two pretty different interpretations of the code.
We do take issue with his interpretation. Our interpretation is that by statute, any surface transportation project, of which obviously a passenger rail train is a surface transportation project, any surface transportation project that utilizes Title 23 funding is then eligible as a qualified highway or surface freight transportation project.
Mr. Goddard, you heard the testimony of the three folks to your left. What is the reaction of Brightline to the substance of these concerns in terms of unfunded mandates, safety, and for that matter, eligibility?
Thank you, Congressman. So we've been questioned on these issues for several years. We've been through several lawsuits on PABs, on safety, on whether or not we meet the criteria. We have prevailed up until this point. We continue to engage in dialogue with with our opponents relative to these issues, and we seem to be talking past each other.
No, but I'm asking a different question. I'm kind of holding in abeyance the litigation and who's an opponent and all that. You know, I'm familiar with lots of different passenger rail systems, commuter rail, for example. And I'll take the western suburbs of Chicago, one I'm quite familiar with. They don't go 110 miles an hour. They have a lot of at-grade crossings, but they also have safety provisions in place, and they can live peaceably side by side. And in fact, communities have grown up around the stations, and it's almost a way of life, but it works. But it wouldn't work at 110 miles an hour, I don't think. So what is your substantive reaction to, if I think you said, Mr. Reingold, 39 crossings?
Ranking member, we have 31 active
31.
crossings.
So if I'm a small county and I got 31 crossings, I have a legitimate concern about safety. What are you going to do about that? How can you help us address that, ameliorate that concern?
Again, safety, the safety of train travel has been demonstrated and again, as substantially safer than traveling by car. I can tell you that passenger rail happens every day in this country, all over this country. Our corridor meets the sealed corridor requirements as determined by the FRA. We don't actually set the speed limits.
Mr. Goddard, with due respect, that's a very bureaucratic answer. I asked you, what are you doing to try to ameliorate the concern about, in the case of Indian River County?
Yes, sir, Indian River
Yeah.
County.
Legitimate concern.
Yep.
I'm worried about kids. I'm worried about people.
Sure. So
and so how is Brightline trying to ameliorate that concern in a reasonable way?
So we have spent the last about 4 years ago when we started this project, in conjunction with USDOT and FRA, we went crossing by crossing with each municipality all the way up the corridor to determine what was the properly prescribed safety equipment to implement at each crossing by crossing, to make sure that we implemented the right safety equipment. These groups, we've had discussions, we've had dialogue with them, and we've met their demands. So if there are additional discussions that my colleagues would like to engage in relative to their needs, we're prepared to have those discussions. But up until this point, we feel like we've addressed all of the concerns.
All right. I don't wish to impose, but if the chair will just indulge one last question to Mr. Crandall, because I was intrigued by your testimony, Mr. Crandall. You've obviously done a lot of homework. You heard the testimony of Mr. Berthy that our review at DOT, this meets the criteria. You want to just take a moment to perhaps rebut that or give your elaborated view of why they're wrong?
Thank you for the opportunity, sir. I think
they're wrong.
Thank you for the opportunity, sir. I think,
and then I yield back. I thank the chair.
I think Mr. Masters put his finger on the issue. The rule is quite clear, and that is that a project which has benefited or received funds under Section 23 might then be eligible. But the fact is, All Aboard Florida has not received such funds. As Mr. Mast, I think, quite aptly pointed out, such funds have been used in prior years to improve the crossing, the point where the road crosses the tracks, perhaps to put paving, et cetera, whatever might have been done. But it was a long time ago, and that's an entirely different project from All Aboard Florida. Thus, it is quite clear to me on the reading of the statute that All Aboard Florida is not eligible. It is a railroad, and it isn't eligible under any of those 15 categories.
I thank the gentleman from Virginia. The chair recognizes the gentleman from Florida, Mr. Posey, for a series of questions.
Thank you very much, Mr. Chairman, for holding this hearing. And Mr. Ranking Member, I want to thank you for agreeing to it. And Congressman Mast, I want to thank you for requesting this hearing. You know, the proposed Brightline service will run through the heart of many of my communities in my district. Obviously, I have a lot of concerns and questions. I've seen the data from the Federal Railroad Administration Accident Database that shows that during the period of 2007 to 2018, there was an average of 13.5 rail crossing deaths per year in Florida. In the short time Brightline has been operating during Phase 1, you've already recorded 6 such fatalities, almost 50% of the annual Florida average. This abysmal performance suggests a serious safety deficiency and should be immediately remedied. One of the questions I'm going to have for Mr. Goddard when I'm finished here, if you'd write this down now and remember to respond to it, is I'd like you to share with me your firm's plan to mitigate the increased risk to pedestrians and vehicles at rail crossings. I read the summary of comments on safety in the 2015 Environmental Impact Statement for All Aboard Florida, pages 1 through 23 of that document. Quite a few residents worried about the safety of grade crossings under the new train service are evident. The Federal Railroad Administration's response was completely puzzling. Most troubling was the response that these safety concerns are covered by FRA safety standards and therefore not subject to the National Environmental Protection Act. So we've got to worry about protecting everything in the doggone world except humans. You know, Mr. Berthy, I appreciate you showing up today. I've written your agency twice with some serious questions about safety concerns, and I've received responses only from the FRA, and I still get very, very poor service and response from your agency at addressing some of the serious safety issues that we have before us here. You know, I'm puzzled how your agency can possibly consider a highway and a railroad the same thing. I mean, what can you drive on a highway? A bicycle, a motorcycle, an automobile, a truck. What can you drive on a railroad track? If you don't have a train, it's no help to you, you know? Maybe you can buy a ticket, you know, one way to, we'll admit it. Given that the NEPA requires the agency to assess the impacts to the human environment, surely we don't intend to cut off the process without mitigating for increased risk to pedestrians and drivers. I'm very puzzled about the rationale for not analyzing and addressing safety in the environmental impact statement, obviously. And at the end, Mr. Berthy, maybe he can give us some further insight and wisdom on that. Construction of Phase 2 of the project, which will bring the train through my district, through Indian River County and Brevard counties, has yet to happen. Many narrow-minded residents, as you call them, Mr. Goddard, are understandably nervous, especially those residents whose homes back right up to the train tracks. There are schools and businesses that are in close proximity to this train. And Mr. Chairman, with your indulgence, I'd like to ask for unanimous consent to include 7 images showing how close the proximity this train runs to my constituents' homes, schools, and businesses. This is a photograph of the crossing of Vero Beach looking north. This is one of downtown Melbourne. Can't imagine a high-speed train going through there. This is one of Stewart. This is St. Lucie crossing. This is downtown Vero Beach looking from the east. And these are residences that back up to the line.
Without objection.
Thank you. Shouldn't we open up the process to re-examine its safety issues in collaboration with the public? You know, we get a pledge maybe to do that today. It's my understanding that all of Board Florida plans to have local governments, like my constituents in Indian River County, pay for the maintenance of the safety equipment necessary to operate its passenger and rail trains across hundreds of at-grade crossings. This is basically an unfunded mandate from the federal government on local governments, something that we always swear that we won't do, and we inadvertently sometimes end up doing that, and this would be a horrible injustice. And given that we're providing substantial support to AAF and the requirements for new safety equipment due to Brightline service, shouldn't the capital and operating costs of safety equipment be paid for by Brightline, the people who benefit from it? Mr. Chairman, let me tell you how I found out about Brightline, about this all aboard Florida. For several years, representatives came through and said, look, we're going to put in a high-speed rail. Here's our plan. We don't need any government assistance. We don't need any government approvals. We're doing this completely in-house. We're authorized completely to do it. It's all on our own. We're just telling you for informational purposes so you'll know what's going on through your district. That went on for 3 or 4 years. And then I'm asked to sign a letter executed by Mr. Mass' predecessor, putting them at a high priority for a RIF loan. And I go, well, I thought you guys were doing it. Well, yeah, well, our plans change. Yeah, they sure do. They sure do change. So when we had a transportation bill come through on the floor, I thought it would be appropriate to have a couple of amendments. You know, one, that you should have the approval of at least majority of your local elected officials to do something like this. And we should also limit the amount of the loans. This would be, I think they were asking for $1.7 billion at the time, the most humongous loan in the history of RIF loans. And, of course, follow the law, because at that time they hadn't got somebody to sandwich in a glitch fix for them because they didn't meet the criteria for the money that they were asking for. Of course, I met with a lot of strong opposition. One of their strongest supporters and advocates, a member of Congress, who's now in federal penitentiary, said twice, shame on me for asking the railroad to actually follow the law. And the floor was flooded with colorful handouts of misinformation about the rail, and of course the amendments didn't pass. They should have, but they didn't. I have correspondence from my local officials asking them, the they were asked by Brightline to write nasty letters to the editor about me, calling me narrow-minded and some of the things to quote Mr. Goddard. And I just think this attempt to do this is everything but straightforward and upright. I believe they tried to sell some bonds before, but they couldn't sell them. And so now that's changed. You know, you wonder how fast these trains travel through these little villages. Even at 70 miles an hour, the consequences can be horrific based on how long it takes to stop one of these doggone things. And you know, I think we've been called narrow-minded and not in my backyard people. And, you know, I think a lot of people would support a rail if it didn't go through the middle of our downtowns and our neighborhoods, and if it was actually safe, which this clearly is not. My own experience, and I think yours and other members of Congress, we were recently in a train accident. And I was advised by one, the reason for that accident, even though the guards worked, is the guys in the truck, one of whom lost his life, we're used to seeing coal trains come around that corner about 30 miles an hour, and they thought they'd have plenty of time to get across. They weren't, you know, accustomed to having our Amtrak come through there at 60 to 70 miles an hour, and the result was tragic, just like it will be in many, many communities in my district and Congressman Mass' district. So, you know, I've heard a lot of talk about overwhelming support for the project. Man, I sure as hell haven't seen that. And I don't think it was so overwhelming support that you were able to sell any bonds before. I don't think people are all stooges, you know, and they're not that stupid to invest in a train. We don't have any lines like this that make any money. The federal government has to subsidize them. The problem with the RIF loan is after you guys would go broke on passenger rail, if that was your real agenda, then, you know, what collateral, really usable collateral, safe collateral, would the federal government have? So my question to ask you right now under oath is, Mr. Goddard, what is your real agenda here?
Congressman, not sure which of your questions to address first.
We can do the agenda question first so we don't forget it.
Our agenda is to improve mobility for millions of visitors and residents of South Florida.
Is there a reason why somebody would get off an airplane, if they were going to Miami, they would get off an airplane that could get them to Miami in an hour and get on a train that would take them 2 hours to get there, and they'd have to do their luggage back and forth in the train? I mean, is the model looked at that as being a realistic expectation? And would somebody in Miami going to Orlando or going past Orlando sacrifice an hour flight to get on a train and unload and load?
Our business case, which Mr. Crandall to my left has made on many occasions, is there are many corridors that are from 200 to 350 miles apart that are too short to fly and too far to drive. There are 400 million trips between Central and South Florida on a daily basis. And yeah, we believe that we can capture a good share of those.
Well, if it just stayed in South Florida, obviously I wouldn't have an interest in this thing. But it's not just in South Florida, it's in East Central Florida, which affects our districts. And as I said before, if you were following a path west to I-95 where there was less population and weren't running through the middle of our downtowns and our school areas, and it wasn't a safety effect, we'd probably think that was a great idea. But, you know, do we want to sacrifice, and I think the answer is no from my standpoint, the safety of our local residents for your profit and convenience?
So if I could respond to that, there was a 2015 report commissioned by Indian River County to study the safety impacts of Brightline. And their own consultant concluded that we can find no decrease in grade crossing safety with the advent of All Aboard Florida. To Indian River County's benefit, the additional capacity improvements, other additional infrastructure, safety improvements, upgraded crossing warning devices, which are regulated by the FRA, implementing suggestions for quiet zones, fencing, pavement markings, a public awareness campaign, and a finding of no additional closure time with the additional trains, draws a conclusion that there is no adverse safety impact to Indian River County from All Aboard Florida. If the proposed upgrades actually occur, they will improve and update the safety factors that exist today. I'd also like to add that again, passenger rail happens in this country every day. And, you know, in Detroit to Chicago, that route has a similar number of grade crossings as Brightline and runs at grade. St. Louis to Chicago has 213 crossings that have been upgraded. Trains travel at 110 miles an hour through dense urban areas in on those corridors as well.
Well, I submit to you that sometimes a picture is worth 1,000 words. And your remarks about it being safe crossings in Indian River County and St. Lucie County don't pass a straight face test.
So, if I may, Congressman, that's a picture of where exactly?
This is Vero Beach crossing.
So obviously we haven't made any improvements there yet. We haven't actually begun construction on that segment.
So, you know, like there's less than one room for one car to back up over here. And of course, I've seen them even for the little local trains backed way up over here. But how would you propose to make this crossing safe?
Again, that's actually determined by the Federal Railroad Authority and US DOT in conjunction with your community leaders. So again, we've, over the last 4 years, met with your community and determined exactly how to do that. Sitting here today, frankly, I'm not, you know, I don't have the answer at my fingertips, but the net is there will be improvements on there that comply with the FRA's sealed corridor guidelines and are safe in other municipalities.
You're going to require these local governments to maintain these crossings forever. Yet your train is not going to stop in any of these communities. They get absolutely no benefit whatsoever from your train, yet they're stuck with the liability of it. You know, how do you possibly think that that's fair and reasonable?
So, for those who may not, for those who may not know, our right-of-way predates, you know, the communities through which we travel. Correspondingly, there are decades-old agreements between each municipality up and down the corridor as each community asked if they could put a road across our railroad. When we granted communities that right to transverse our railroad, we the cost of creating the gates, the bells, the whistles, was actually, that burden was on the community.
Well, when you said we, you didn't make those agreements.
If
Flagler made those agreements. You know, you're an international hedge fund now. You know, you had no dog in the fight at that time, and those agreements are probably 100 years old. Obviously, they were intended for not high-speed trains going through their little towns, but trains that would actually stop in their towns if necessary and help promote their commerce and passengers at one time.
It sounds like you might like a stop.
Yeah. So
no, you know, that wouldn't appease me. I know that's been one of the latest, you know, things that they've thrown out from saying absolutely positively there will never, ever, ever be a stop in this high-speed rail, because then it wouldn't be a high-speed rail. To appease some critics, I understand you have lately been saying, well, we might have a stop in your town, and we might have a stop in your town, but we know that that's not going to happen, because then it'd take a 5-hour ride on a high-speed rail to get from Miami to Orlando, and, you know, 5 times longer than the airline flight.
So go ahead. You can respond to that. We're going to do a second round of questioning, but you can go ahead and finish up on any response that you have, Mr. Goddard.
Thank you, Chairman. So just for the record, it's important to understand that there are long-standing agreements, and in fact, the responsibility to improve the crossings are actually the municipalities as well. Although we have actually taken on that financial responsibility up and down the corridor. We have improved all of the crossings up and down the corridor. We've done that on our dime. We have not asked the municipalities to participate in that, but yes, they do need to continue to pay the maintenance that they agreed to pay.
All right. I thank both the gentlemen from Florida. We'll come back and let you ask a second round of questions. Chair recognizes himself for a series of questions. Mr. Berthay, would you agree that this does not qualify under number 11 on the statute, 26 USC code? It is not a high-speed rail project. Is that correct?
Yes, sir. I would agree with that.
Okay. Would you agree that it does not qualify as a highway under that same statute?
The Department of Transportation does believe that it qualifies.
So you're saying the Brightline rail project is a highway. That's your sworn testimony.
We're saying that the definition of a qualified highway or surface.
That's not what I asked you. Is it a highway or not?
It fits the definition under the statute.
Well, it's interesting you say that because the definition under your guidelines and under the code would indicate that it is a surface transportation project. Now, I happen to serve on the on the Transportation Infrastructure Committee. Secretary Chow would agree that surface transportation are not rail. And so you're at odds with your own secretary on that.
Again, our interpretation, longstanding of the statute, is that any surface transportation project, including passenger rail, which utilizes Title 23 funds, does qualify under.
So how much Title 23 funds does somebody have to spend in order to qualify?
The statute does not specify.
So $1?
Theoretically, yes.
So do you believe that that was the intent of Congress? I can tell you it wasn't. This is a softball answer. The intent of Congress was not for $1 of Title 23 money to be able to qualify them for a PAB. And so if you're going forward, and as you go back to the Department of Transportation, if that's their interpretation that $1 qualifies them, then everything qualifies. Because anybody would spend $1 to say I can get some tax-exempt money from the federal government, wouldn't you think?
Well, what I would say is that private activity bonds are a very useful tool to minimize the federal dollars that are required in a project. So they enable us to fund projects without having to.
Listen, you're preaching to the choir here, and so let's dispense with that. I actually support private activity bonds, and in the tax reform package in the House where it was excluded, I actually said I wasn't going to vote for it unless we got private activity bonds back in there. As you know, it is part of that. I see the critical tool that it is, but we must also understand that Congress has a certain intent on how those are to be used. And when the Department of Transportation uses their wide discretion in what qualifies, and it undermines the very fact of why we have private activity bonds, and it makes members of Congress like me who have advocated for it say, how in the world can you say that $1 in Title 23 funding would qualify somebody for a PAB? Right. Is that your sworn testimony here today?
Well, this project did receive more than $1, to be clear. It received
I'm asking
$1 million.
Does $1 qualify?
Technically, under statute, under my understanding, yes, it would.
Okay. So your sworn testimony is that the intent of Congress was that $1 would qualify.
I cannot speak to the intent of Congress.
Well, but you're here to actually convey the intent of Congress. That's the whole reason why you write rules and regs, are to take the laws that we pass and actually have the intent of Congress to go forward. Is there any scenario where you think that there was some member of Congress who said, if you'll put up $1 of Title 23 money, that will allow you to do $1.75 billion in private activity bonds? Do you think any member of Congress could go home and get reelected based on that kind of rationale?
Our responsibility is to consistently apply the statute as it's interpreted by our department, and that is.
So how do you do that consistently? That's your word, consistently, when there is not a standard of how much money has to be put in terms of Title 23. So somebody, Mr. Goddard, could come up and listen. It's not my backyard. And, you know, they're not going to run high-speed rail to western North Carolina. But I guess under your scenario, it would qualify. Because if they've used, no, it has to be in the state, right? So you're saying that anywhere in the state of Florida, they can run high-speed rail because we have some amount of money for a crossing that was paid some time ago. Is that correct?
We're not saying that. We're saying that if...
Well, where does it stop? It obviously doesn't stop at Orlando, so where does it stop? Does it stop at
here specifically,
Jacksonville?
The Title 23 funding was spent after All Aboard Florida announced all their plans.
For what?
For grade crossing improvements.
For grade crossing improvements, where?
Along the tracks where the All Aboard Florida trains will run.
All along the entire corridor?
I do not know the exact grade crossing.
I do. I mean, I'm asking a question that I already know. So how much of this second phase of this was Title 23 funds used to improve crossings? Do you know that amount?
All Aboard Florida's application indicated that subsequent to their announcement of their project in 2012, 13, and 14, $9 million were spent.
In this second phase?
Along the second phase of the corridor.
Okay, and where was that spent?
Again, I don't know the exact grade crossings, but spent on grade crossing
Okay,
improvements.
you have 30 days to get that to this committee. Do you have that? Is that a reasonable request?
We do have the information, yes. I just don't know.
So is 30 days, I'm looking at your staff to see if that, because it's really their work, not yours. So is that adequate time?
Yes.
All right, so in 30 days you can get that to us. So let me ask you a little bit further, because I do not see this as fitting the definition of surface transportation, and not even under, if you read even the statute, it doesn't seem to apply. And so at this particular point, I have a real concern that the intent of Congress is being overridden with the private activity bond measure here, because it's really all about, we wanted cooperation between a state and a federal entity, and when we looked at this, we wanted that cooperation to take place. Wouldn't you agree with that, Mr. Berthay?
Cooperation between a state and a federal entity?
Right.
That makes sense.
Okay, and so we want that cooperation, and so what you're saying is if we fix some kind of road that happens to go over a rail, that automatically qualifies the entire rail project that's going in a different direction, because a freight transfer system is not what we're talking about here. Would you agree with that?
So for example, we would draw a line.
Answer the question, is this a freight transfer?
This is a passenger rail system.
Okay, so under the definition of 15, we now are coming down to part of the definition is this a surface transportation issue or not? Would you agree? That's the only part of this statute that could possibly apply.
The statute specifically says that whether or not it's a surface transportation project, which receives federal assistance under Title 23. And again, I reiterate the statement I made before, that our conclusion was that it did.
All right. So would you suggest that this is not a freight transfer facility? So that's the second part of that.
There's a distinction between applying that specific phrase versus the statutory definition.
That's correct.
The statutory definition of a freight transfer facility includes a surface transportation project, which
no, well, it actually that's the third paragraph. I mean, actually, I've actually done a little bit of reading here, and any facility for the transfer of freight from a truck to rail or a rail to truck, it is obviously not doing that. Is that correct?
It is not doing that, but our definition is under M1A.
So under A is any surface transportation project that receives federal assistance. So what you're saying is that you can give money to a highway and build a railroad right on top of it. Because surface transportation, let me just tell you, you may want to say, well, this under the definition, and we've got very high-paid lawyers sitting behind Mr. Goddard who would say, well, anything that is on the surface actually would qualify. Is that what you're saying?
We're not saying anything.
He's shaking his head, yeah.
It does need to be related to the project.
So how is a railroad crossing on a road necessarily being a fraction of the cost related to that?
Well, obviously here, given all the safety concerns that have been mentioned, improving grade crossings is of the utmost importance.
So what percentage of the project does the Title 23 funding have to be?
There is no percentage that's placed in statute.
So everything qualifies for a PAB?
Based on our statutory interpretation, yeah.
Okay, well then I would suggest to my colleagues that I guess we need to change the law, and what is going to happen is, and I don't agree with that, I understand that your interpretation is that. I think the intent of Congress was very clear, and that was not the intent. But in doing that, perhaps the Secretary needs to look at the rules and regs, because you will have a real problem continuing on with private activity bonds being there. Mr. Goddard, let me come to you. You said that the taxpayers are not subsidizing this. Was that your sworn testimony?
That's correct.
All right, so that's one. I don't believe that to be the case. But if that's the case, if the taxpayer has no exposure, and it is of no consequence to the taxpayer, why don't you get private funding for this?
We certainly could.
Well, why don't you? I mean,
because
most of this hearing would go away if you did that.
Yeah.
So why don't you go ahead and get private funding? It gets me out of it. It takes a problem off of my desk. And you know what? Why don't you go ahead and get your own private funding? And you're saying that you can get the same private funding at the same benefit without the taxpayer having any subsidy in that.
Yes.
Is that what you're saying, Mr. Goddard?
No, Chairman. So the reason why I'd love to alleviate you of this burden, however, the reason why we are interested in a financial instrument such as PABs is it's a cheaper cost of money. It is a less
Well,
expensive
then
cost
it
of
is
money.
taxpayer subsidized. So you're sworn,
Sorry, so taxpayers subsidized, and again, what is your definition
well, your
of
sworn
taxpayers?
testimony, I asked you to clarify it because I didn't think I heard what you said the first time, and I didn't believe it the first time, and then you reiterated it. There is a benefit to your company that comes at the expense of the American taxpayer, is there not?
There is a deferral of taxes to investors. But the intent of
So
the
there's a
PABs
tax benefit to somebody, and let me just tell you, this.
there's a distinction between that and receiving money from the government. This is a loan.
I didn't say that you were receiving it.
Right.
Listen, I'll say this nicely because I've already criticized you for some of your opening remarks. I will say this, that what happens is PABs, by their very design, are designed to be a tool to make it more affordable for us to do projects with the Department of Transportation. In doing that, we have to recognize that there is a federal component to that. Would you recognize that there is a federal component to private activity bonds in that there is a deferred ability under tax law?
So
I can give you the IRS code if you want.
I'm not an attorney, Chairman Meadows. I run the company. We have attorneys who understand these matters far better than I do. You've heard Mr. Berthay's testimony. I feel that I don't have an awful lot to add in this context. We've been to court 3 times on this matter, and I think that we, again, to the extent that we're now in a new lawsuit on this, I don't wish to comment further.
Well, that's not an option that you have, Mr. Goddard. You're here under sworn testimony, and that's the reason why it's not a criminal conviction. We can't bring any criminal charges towards you here today, but you do have the responsibility to uphold the truth and your testimony and answer the questions. Now,
so to the best of my knowledge, I mean, you've heard Mr. Berthay speak about the PABs, and USDOT determined we're eligible. Our legal team has looked at the issue. They also agree that we qualify. We believe we qualify because we received Section 130 funds.
You've received Section Title 23 funds?
Title 23 funds.
Okay.
And
fine. I got your testimony. So, Mr. Reingold, you're saying over 2030 that it's going to cost your county 8-point-something million. Is that correct?
8.2 million, Congressman.
Is that high, Mr. Goddard?
honestly, I'm not sure.
Okay. So are you stopping in Indian River County?
No.
Okay, so he's going to have to maintain railroad crossings so that you can get people from one area to another, and it'll go through his county. And listen, I'm all about commerce, and I realize that it's always in somebody's backyard, so I don't know that I have a whole lot of sympathy about it not being in my backyard. These two guys do. But here's my concern, and it is with unfunded mandates. If you're asking his county and his city to support the maintenance ongoing, and I would see that as a tangential cost to your particular operation, would you not?
Again, we have existing agreements in place that, again, I don't know what the material increase is from prior to Brightline.
So if you're asking their county to spend $8 million for a new railroad crossing maintenance, do you not see that they wouldn't have to do that unless you were coming through their county? That's an easier
Well,
question.
they wouldn't have to do that. I mean, again, the road crossings, this is our private property. We're trying to run our business on our private property.
And what I'm saying is
a
I get
requirement.
that. Listen, there's no one, in fact, I can tell you, I'm the most conservative on private property rights of anybody on this dais, I promise you, being from Western North Carolina. And at the same time, if you're going to do railroad crossings and you're going to ask them to maintain something that they don't get a benefit from, do you not see a problem with that?
I can see how, potentially.
Okay. So here's what I would ask you.
What I would say, though, if I may, Chairman, we have actually spent the money on improving those grade crossings. So we did not turn around and ask.
Yeah, I don't disagree, and I've heard that, and let me just tell you, you're going to find that I will be willing to look at the truth in every argument, and I get that, because I could see your counsel when the chief was talking about how they were having to spend the money for all these railroad crossings. I could tell your counsel in the back, he was shaking his head and saying that, don't ever play poker, by the way, but in doing that, but in doing this, here's what I'm saying. Is there are legitimate safety concerns that the chief has made, and for you to
I'd love to address those.
Well, I know where you're going. You, in your opening statement, you talked about the opioid crisis.
No. I think there there's actual real misinformation. There was actually like a misstatement of some facts there. Like I would love to have a conversation with the chief.
We'll have a second round. I will give you the opportunity, and if I haven't, you can remind me and nudge me to give you the opportunity for rebuttal, and I'll be. But here is my concern. If you're asking this county, and more specifically their taxpayers, to fund the maintenance of railroad crossing in perpetuity, and they don't benefit, it has to be at least a cost consideration for this project. And in doing so, and I know you're shaking your head no, I don't know.
No, I'm just... We have agreements in place. This passenger rail is not a new phenomenon.
You have a lot of things in place that may be at jeopardy, Mr. Goddard. So let me just suggest to you, that you come back to this committee with how you're going to address these types of concerns. Are you willing to do that in the next 45 days?
Certainly.
All right. So you're going to come back to the committee on how we're going to address the ongoing maintenance concerns that may happen with, and obviously Mr. Reingold is here for his county, but as we look at some of those other counties, if you would do that, that would be very helpful. With that, I'm going to go ahead and recognize the gentleman, Mr. Mass, for a series of questions.
Thank you again, Mr. Chairman. Mr. Goddard, does FEC have agreements in place, or does Brightline have agreements in place with Indian River County, with Martin County, with St. Lucie County?
FEC.
Is FEC Brightline?
No, FEC is not Brightline.
So then, is there new upgrades to these crossings that has to occur as a result of the Brightline crossing, not as a result of the FEC project?
So I think it's important to clarify, Congressman, that All Aboard Florida owns the perpetual right and permanent easement to run passenger service on the FEC railway between Miami and Jacksonville.
FEC is not Brightline, though.
That's right.
And the agreements are with FEC.
That is correct.
The new infrastructure is as a result of the Brightline project. The new expensive infrastructure that Mr. Reingold's county will have to pay for the upkeep of.
It's shared infrastructure.
Got it.
It's shared infrastructure.
And on all of the safety upgrades that were conducted throughout the entire corridor of train, I do read out all of them. It does say FEC crossing, FEC crossing, FEC crossing for everything. And so it's in that. I want to get to the truth in testimony for what I was able to question your CEO on transportation and infrastructure, or the truth on the Department of Transportation application, and get where we left off before. As I said, All Aboard Florida CEO, Mike Renninger, he testified June 23, 2017 in Transportation and Infrastructure to me to a question that I asked, that All Aboard Florida is not publicly funded at all. But we've been having this entire argument throughout this on whether there is even $1 of public funding that has gone to this project, which would allow it to qualify even as a highway or a freight transfer facility. And we've gone back and forth. Is there $1? Is there not $1? Is there a limit to it? The testimony to me on transportation and infrastructure is not publicly funded at all. It's completely an investment of private sector capital. So I will ask one more time. Your answer before was, he did not lie to me. That was your answer before. He did not lie to me when he said it's completely private. So on the application, was there not truth on the application where you're saying there was public funding used, which would enable you to get these private activity bonds?
The funding that was received through Section 23 was for what is now the shared infrastructure, and it was intended to improve crossings and the safety of crossings throughout the corridor.
So you maintain there is public funding in this?
There has been public funding granted to the corridor.
So it was not truthful when you testified to me on transportation and infrastructure.
Well, again, this was, so there's a distinction between, I suppose, I'm not sure of the timing of the funding. Honestly, Congressman, I don't know exactly when the timing was. I'd need to get back on you, but back to you. Whether the funding preceded the inception of All Aboard Florida or not, I'm not certain.
Please get back to me on that. Mr. Berthe, I want to get to you. So it sounds to me, and I heard you use the word indicated, probably at least 3 or 4 times as we were talking about the application of FEC, Brightline, All Aboard Florida, whichever company it was. And it sounds to me as if from their testimony thus far, the Department of Transportation did base the eligibility of the decision for private activity bonds on All Aboard Florida's self-reported acceptance of Title 23 funds. That whole argument of whether there was federal funding or not federal funding, whether there was truth or not truth in the testimony on transportation and infrastructure. So did the department investigate All Aboard Florida's claims in their application at all?
The department does review all components of the application, including the actual use of Title 23 funds that a sponsor claims.
Does the department determine FEC to be Brightline? Are they the same company to the department?
That is not a consideration that the department makes, and given pending litigation on that issue, I cannot comment further.
So the department does not look at whether one company received federal funding and whether a completely separate company is applying for private activity bonds. That's not looked at in an application when one company is claiming that they received federal funding.
Unfortunately, Congressman, I cannot comment further on that given litigation that's pending.
Okay. I would hope that you could comment on this, being that this is the primary concern of how we're determining whether somebody is eligible for private activity bonds. The department does seem very unsure whether All Aboard Florida actually received Title 23 funds or not, and as we said, that's what the application is entirely based on.
So, Mr. Berthe, hold on, just if the gentleman will yield for just a second. So, Mr. Berthe, are you suggesting that you don't know whether you evaluate that or not?
I'm not suggesting that. I'm suggesting that the overlap between FEC and All Aboard Florida is the subject of litigation. I've been instructed by our counsel to not comment on that matter. All
right, so let me ask you this. His question is more generic. Do you typically evaluate whether one entity and another is one and the same? Do you typically do that? Which would not speak to the litigation at bay here or at bar. I mean, do you typically evaluate that?
Well, obviously, all applications are very different, and so it would be on a
right. So either it's typically evaluated or it's not, because all applications are evaluated differently. But you would say, do you consider two different entities, to Mr. Mass's point, as one, typically? In all your reviews, obviously, if you're prepared for litigation, you've already looked at this. In all of that, would you typically do that?
Well, certainly, Congressman, Mr. Chairman, we do very significantly take a look at the applicant that is requesting private activity bond allocation. But with regard to whether or not one entity is judged versus another, I mean, I think it's difficult to answer that question on an overarching basis. I think it's very situational.
Well, can you confidentially get your counsel, and certainly with the DOT's help, respond to this committee in 30 days with specificity? I see your staff's nodding yes. Is 30 days enough? All right, thank you. I yield back.
Thank you, Mr. Chairman. I'm going to complete my line of questioning with this, and I'd like to go to Chief Wooters for a minute here. In all of your time in looking at safety issues, have you experienced the push on the county, or have you heard, Mr. Rangold, the push on your county to say that because there is uproar about the 32 trains and train horns blowing 32 times in the backyard of everybody or in the downtown of everybody, have you been approached by the Brightline project about the fact that there can be quiet zones, or that they can be quieted, or they can not blow the train horn?
Thank you, Mr. Congressman. Yes, we have been approached about them. At this point, the county's position is we don't feel that it's a good thing. We recognize a significant change in the train speeds and frequency through the area is something that the community needs to have time, if you were to come to understand how it works, much like Congressman Posey had mentioned in the incident that happened on the train that you were on. They have to come to understand those changes in speeds affect the way they make decisions, and we don't think that quiet zones are an important thing to put in. We think that all the safety features should be working as normal, not agreeing to those quiet zones.
Mr. Rangel, do you have a comment?
We have concerns with the quiet zones as well. As we've seen already in South Florida, there have been significant accidents and incidents already, and we certainly will take the consideration of quiet zones seriously, but we are very concerned about the safety of this project, and thus are not jumping instantly into that issue.
Mr. Goddard, you did mention quiet zones briefly in your written testimony. Is the possibility of quiet zones something that you push on the localities or encourage to the localities?
So the quiet zones are completely at the option of the municipalities through which we travel.
In order to avoid outrage of a train horn blowing at every intersection in an area, have you encouraged the city of West Palm Beach or any other cities to consider permitting quiet zones?
No.
Okay, I don't know if you're aware, but this goes to the point, and I'll finish with this. This goes to the point of the continued cost of this project, not just at the local level or potentially the state level, but also at the federal level. Just last week, the mayor of the city of West Palm Beach, she was in my office, and she was very specifically asking me that the federal government pay for increased infrastructure at every intersection because they permitted every intersection as a quiet zone as to avoid the outrage in their community of this train traveling through it 30 times, and they now wish that the federal government will pay to get those quiet zone permitted intersections up to a higher quality because of the deaths that have occurred. This is in the area that his train is running, and this is just, in my opinion, another example of where the federal government potentially gets on the hook for the cost of this line, not just from where FEC or Brightline is asking for dollars, but where the cities and the municipalities come and ask for those dollars as well, especially in the result of safety concerns. In that, Mr. Chairman, I thank you for the time today, and thank you for the hearing. I thank all of you for your testimony to me. Thank you.
I thank the gentleman from Florida. I'm going to recognize the other gentleman from Florida for a probably more straight 5 minutes because I gave him a very generous 5+ minutes in his opening round. So the gentleman's recognized for 5 minutes.
Thank you again, Mr. Chairman, for holding this. And it's so enlightening. I mean, I'll be eternally tormented trying to figure out how in the world a highway is the exact same as a railroad. And if you can solve that puzzle, or you can before I do, share it with me, because it's Mr. Berthy, in 2005, Congress passed a Safe, Accountable, and Flexible, Efficient Transportation Equity Act. I know that sounds all oxymoron, but we did, and they did. And it created a $15 billion pool of tax-exempt bonds that could be used on eligible tax-exempt facilities. In order to obtain these tax-exempt bonds, private sector entities must submit an application for review. And what I'll ask you to respond to in writing, since we do have a very limited amount of time here, is if you would be kind enough in the next 30 days to let me know if there is a high demand in the private sector for these bonds, how many applications DOT receives, how many applications are typically approved and how many are denied, who oversees, precisely who oversees the application review process, like name and position numbers, how long the review process for applications typically takes from start to finish. If you could do that. Can you do that in the next 30 days?
Yes, sir.
Thank you very much. Generally, given that there's a $15 billion pool that we just talked about, how much do project sponsors request in tax-exempt private equity bonds?
In other words, on average, what's the average of our applications? Yeah. It varies wildly. It's always in the hundreds of millions at least, and sometimes into the billions. Okay. And roughly how many requests are we talking about? Over history or in a given year? Or in a given year. In a given year, I believe last year we approved somewhere in the neighborhood of 4 to 6. Okay. In your correspondence to me, if you could also briefly walk me through the application process. I know it's set in statute somewhere, but if you would include that in the letter, I have another reason for requesting that. Okay. Yes, sir. Who makes a determination of whether a project fits under one of the 15 categories in 142A? The department does, sir. Ultimately, the discretion for the program lies with the Secretary of Transportation.
The Secretary then?
Ultimately, by statute.
Okay. Typically, does this project sponsor have to specify the type of exempt facility in their application?
Well, the Department of Transportation only manages the $15 billion with regard to the qualified highway or freight transfer facility. That's the only definition that applies to the $15 billion cap.
Okay. So does DOT give any difference to or rely upon the project sponsor's evaluation of how their project is eligible?
Yes, we do.
Okay. Mr. Crandall, would you like to comment on the record further about the judge's decision as to the cost of the taxpayers of the subsidy?
Thank you, Mr. Posey. In the district court, the judge heard testimony as to the probable cost to taxpayers and reached the opinion that the original $1.75 billion, if granted, would cost taxpayers about $600 million during the first 10 years of that bond issuance.
Okay, thank you. Mr. Goddard, is the RIF loan application still pending?
Thank you, Congressman. If I could just clarify Mr. Crandall's response. So the $600 million was actually a number that was formulated by one of CARE's consultants. Was not actually, didn't come from the judge. We ran our own numbers. It's probably around $250 million.
Okay. I'm running out of time here. So.
Yeah, and we actually have there'll be a tax benefit of about $650 million from that investment of $250 million.
Back to the RIF loan. Is this still pending?
Yes, we are actively in the process of applying for a RIF loan.
And how much is the RIF loan for?
$1.75 billion.
Okay, that's $1.75 billion with a B?
With a B.
Okay.
If I may, Congressman, this is Dylan Reingold.
Why was the decision made to seek funding through the tax-exempt private equity bonds?
I think as a private entity and stewards of our investors' capital, we're going to avail of any funding available that's at a lower cost of capital.
Okay, and what other sources of funding has All Aboard Florida used to fund Brightline or attempted to fund Brightline?
So in addition to, obviously PABs and RIF are options for us, but should they not materialize, conventional debt's an option.
Okay. Mr. Chairman, I thank you for your indulgence.
I thank both the gentlemen for your leadership on this particular issue. Mr. Reingold, I think you wanted to respond, and I have not forgotten Mr. Goddard's ability to offer rebuttal on something, but to go ahead, Mr. Reingold, if you want to respond to Mr. Posey's line of questioning. I think you tried to interrupt him and didn't get recognized, so go ahead.
Thank you to the chair. 2 points I want to make about the litigation which has been discussed. First off, there had been a mention that the All Aboard Florida had prevailed on all of the lawsuits. I just want to state that the federal court had found that, in fact, that the court had found that the plaintiffs had adequately alleged the existence of a major federal action. That was a significant win for the counties. Additionally, specifically to the point as asked by the congressman, was that the judge found that over a 10-year time frame, that the amounts to what would amount to a $370 million to $600 million cost to the taxpayer. So that was exactly the information that was found and determined by the federal court, not just by Cara Fell's consultant, but actually by the court. Thank you very much for letting me clarify.
Thank you for your clarification, Mr. Goddard. I think you wanted to speak to the safety issue. If I recall that you said there was some misinformation out there, and I told you I'd come back. I want to be good to my word there.
I appreciate that very much, Chairman, and I want to recognize the good work that all first responders do in our communities, but I would like to just point out that the maximum allowable speed for freight trains are 60 miles an hour, not 70 miles an hour. This image of chaotic disruption of trains running through the counties is a little bit misleading. Freight trains obviously take a lot longer than passenger trains to get through a crossing. It takes us all of about 45 seconds to get through a crossing. It's actually about half the time of a red light. Brightline will only run 32 trains, far fewer than most systems throughout the country. In South Florida, there's already a local commuter system that runs 52 daily trains over 72 grade crossings with no impact on first responders. In one suburban Chicago town, they run 102 daily trains at grade. In Long Island, more than 800 trains run over 200 crossings. So again, if we believe that short passenger trains are going to create the kind of disruption that Brightline opponents claim, then perhaps we should consider shutting down all commuter and intercity rail systems in the country.
Well, obviously, we're not debating that particular issue today. That's a little bit of hyperbole, but I will let the gentleman make his case, and point well taken in terms of how quickly it would go through. Listen, obviously there are three different debates that are going on here. One is the fact that there are some who don't want this built for any reason whatsoever. I recognize that. There are two other very significant debates that are going on, and it is the proper use of private activity bonds and the way that this has come about, and the safety concerns that create an unfunded mandate for some of our municipalities and counties along the way. Those are two very different arguments that, quite frankly, have a lot more, perhaps less passion behind them, but a lot more material facts, Mr. Goddard. And unless we are able to answer those questions to the satisfaction of the American taxpayer, we're going to create problems for Secretary Chow and Mr. Berthe and the others, because quite frankly, what we're doing, and what I see this as, is the PAB that you're looking at is being used in a way that is not consistent with the original intent of Congress in that. And your counsel, again, is shaking his head no, but that's all right. What we have is we have monies that was spent for a crossing that goes this way, and we're building with PABs something that goes the exact opposite way. And when we look at that, this was all about trying to have a partnership for Title 23 funding along with PABs and other things to create a highway going one way, understanding that on the rail transfer side of things, they were saying, we understand that there may be these, like there would be with a seaport or airport, there would be these facilities that should qualify, neither of which the money, Title 23 money, has been spent for. So what we will do, for your own edification as well, is we will get some of the legislative history that I don't think is consistent with the interpretation of DOT, or perhaps the way that it's done, because I can tell you, based on our initial research, this may not have been the best vehicle to use a private activity bond. That being said, I want to thank all of our witnesses for coming, and specifically Mr. Goddard. Listen, I know this is like going to the dentist. We're now getting it over, so you're getting out of the chair. I get that. I was a developer. Listen, there's no one who has seen not in my backyard more than I have, and at the same time, we have a responsibility to make sure that we do things safely and with integrity, and making sure that we don't create a financial liability for other entities. That is a big concern of mine, hearing what we have for these counties, and knowing that we can say okay, because you know what? We don't face the same taxpayers when their county commissioners have to raise rates to pay for that $8 million over a 10-year period. So we really need to address that. Mr. Berthe, I thank you for allowing for short time frames. I thank your staff for doing that. Give my best to Secretary Chow. And as we look at this, I want to make sure that we know we're going to leave the record open for 2 weeks for any other opening statements that any of our members would like to make, especially in light of the fact that we're holding this on a day that we recessed yesterday. And additionally, any additional questions. So all of you may be getting additional questions, 2 weeks for additional questions for the record. I would ask that you respond to the committee's request. We will try to be gracious in terms of the amount of time that you have to respond to those questions. And if there is no further business before the subcommittee stands adjourned.